This video is about 5 early steps you can take to help protect your invention. My name is Nick Chiara. I'm a U.S. registered patent attorney with Chiara IP Law. We provide patent drafting, patent filing, and patent searching services. We also provide trademark clearance and trademark filing, and we can provide any IP assistance that you or your business might need. So what are the 5 early steps you can take to help protect your invention? The first step is a preliminary knockout search. The second step is determining when you need to file your patent application. The third step is determining what type of patent application you need to file. The fourth step is beginning the drafting of your application and your drawings. And the fifth step is to begin drafting your claims. As a patent attorney, my general advice for independent inventors is always to have professional assistance when preparing and filing your patent application. However, it is undeniable that preparing and filing a patent application is an expensive process that often comes during business startup when financial resources are at their lowest. The following are a few steps that any inventor can take to begin the patenting process. Even if you ultimately decide to seek professional help, taking these early steps can help crystallize the invention in writing and reduce professional drafting costs down the road. Preliminary knockout search. Preliminary search can help when deciding if pursuing the patenting process is worth the effort. The search will attempt to determine if your invention is novel and non-obvious. Novelty and non-obviousness are the two major criteria that the United States Patent and Trademark Office, or USPTO, weigh when deciding whether or not to allow a patent application to issue as a U.S. patent. The question is whether your invention is new and not obvious in view of the prior art. So what is prior art? Prior art are physical embodiments such as marketed products that you could find available online or in a store, or published disclosures such as articles, patents, patent applications found in any language anywhere in the world. So prior art can be very broad. Novelty generally means that the invention is not anticipated or the same as the prior art. The novelty hurdle is often easier to overcome because at least one or more elements of your invention usually differs in some manner from the prior art. Obviousness is often the bigger obstacle. Your invention must not be obvious in view of the prior art individually or in combination with multiple pieces of prior art. One way to search for prior art is to perform an internet search, such as a simple Google search using search terms that help describe your invention. Additional way to do a prior art search is to use the United States Patent and Trademark Office patent and application databases, which can be found at USPTO.gov. The USPTO databases are generally user-friendly, but first-time searchers should understand that there is a skill to performing accurate and relevant searches at the USPTO database. While it is nearly impossible to definitively say any patent application will be patentable, a knockout search can provide a modicum of optimism. Essentially, what you're doing is you're trying to find any anticipatory references that would say, this is a knockout, don't even bother filing for this application. If you don't find those anticipatory references, you have a pretty good idea that you can proceed with the patenting process. You might still run into obviousness arguments, that's potentially always going to happen, but you haven't found that knockout reference that says don't even bother starting. The second step is deciding when you need to file your patent application. Generally, you should seek to file your patent application as soon as you have a full understanding of your invention and how you intend to make or use the invention. It is not required to have a working prototype. Additionally, inventors should always file their applications with 1 year of any offer for sale or public disclosure of the invention to ensure that your disclosure of your own invention does not become prior art against yourself. If you think you need international protection and you intend to file your patent application internationally, this issue becomes much more complicated and you should definitely seek professional assistance. Now, what kind of patent application should you file? There are 3 types of patent applications: utility, design, and plant patent applications. For today's purposes, we're not going to get into what plant patents are. Additionally, there are 2 types of utility applications: provisional applications and non-provisional applications. Utility applications are for functional inventions, for example, products, methods, and processes. while design patents are for the ornamental features of a product. Think of the shape of an iPhone or the design of a piece of furniture. Provisional utility applications can be thought of as an optional bookmark that must later be converted to a non-provisional application. If the provisional application is not converted to a non-provisional application, it goes abandoned after 12 months from filing. The advantages of provisional applications are that they have reduced filing fees and allow the inventor to secure their filing date or priority date for prior art purposes, and then provide the inventor with additional time to determine the feasibility of pursuing the invention. Essentially, it gives you 12 months to decide if you want to spend more money on pursuing a patent. Additionally, provisional applications are not examined and therefore generally do not have any back and forth with the USPTO, which we refer to as patent prosecution. This provides additional savings, at least in the short term. Non-provisional utility applications have higher USPTO filing fees, but those are necessary to pay for the examination, the searching, and they also require prosecution, the back and forth between the inventor and the patent attorney and the USPTO. Now, you're not required to file a provisional application to file a non-provisional application, but you must eventually file a non-provisional application to ultimately receive a patent. The provisional application is the bookmark. The non-provisional application is the application that eventually becomes a patent. Now, step 4, begin drafting your application and preparing the drawings. I would generally suggest non-professionals start with the specification when drafting utility applications. Provide a detailed description of your invention, explain what your invention does and how it is special and unique, and how its features add improvements over the prior art. Include detailed ways of constructing and using your invention, variations on how your invention can be built or used, and various materials that can be used to manufacture and or practice your invention. Where helpful, provide drawings to explain how your invention works, providing reference numbers in the drawings that are cross-referenced in the text of the specification. A good starting point is to find a patent application on similar subject matter. You can often do this from the references you found during your knockout search in step 1, and then use those applications as an outline for your application. For design patent applications, you will need a very short specification and at least 6 drawings from different perspectives. While design applications are less complicated to draft and file than utility applications, there are still many aspects of the drawings as well as potential prosecution that are greatly benefited by the assistance of counsel. However, even if you are not employing a patent attorney to prepare your design application, it is highly beneficial to employ a professional draftsman or graphic artist that is familiar with USPTO drawing requirements. Otherwise, you may run into rejections for your drawings that require you to start off from the beginning and file a new design patent application. Now, the 5th step is claim drafting. The scope of protection provided by a utility patent is defined by the claims. The claim language acts similarly to the property description within a deed for real property. The claim defines the metes and bounds of the protection provided by the patent. The language employed in a patent claim must be found and defined in the specification. Support for the claim language is one of the essential features of the specification of a patent application. In practice, the USPTO examiners will often read the claims first and then look to the specification to answer questions about claim language. If proper support clarification cannot be found in the specification, the USPTO may issue rejections based on written description and indefiniteness. These rejections can be just as deadly as novelty and non-obviousness rejections with regard to whether or not you actually get an issued patent. Further, the patent claim must not be so broad that it reads on known subject matter. This is one of the balancing acts necessary for a successful patent claim. The claim should define the invention as broadly as allowably supported by specification, without encompassing subject matter already known in the prior art. Unfortunately, for most inventors, this is an aspect of patent drafting where science tends to give way to law and form. And this is one of the critical areas where experienced patent attorney can help with the patent application process, getting these patent claims properly drafted and put into your patent application. Hopefully, the above discussion provides encouragement and does not frighten away too many budding entrepreneurs. What should always be noted is that pursuing a patent is a business decision. in which the inventor must weigh the costs and benefits. Patents can be an exceedingly helpful tool in advancing a business. The patent can become a shield to protect against competition or a sword to provide additional funding sources through investment, licensing, or assignment. But like most things in life, if you decide filing a patent is worth doing, it's worth doing right. Take your time, draft a detailed application, tweak it, improve on it, consider seeking professional advice, and above all, don't become so intimidated by the process that you never begin. If we can provide you with any assistance in your patent drafting and patent filing, please contact us for a free consultation, chiaraiplaw.com. Thank you very much.